Hello, legal warriors. Are you interested in what your duties are when a police officer is either trying to stop you or they have stopped you? Well, if so, this is the video for you. My name's Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years, and I was a prosecutor for 7 years before that. So I know a little something about what the law says when it comes to our duty to obey a police officer. There's a couple different statutes that apply, and the main one I'm going to cover is failure to obey officer. Basically, that is a criminal statute that says if we do not pull over when we are signaled to do so by somebody reasonably identifiable as a police officer, then we commit a misdemeanor crime. Okay, that means not a felony, a misdemeanor crime. A misdemeanor has typically 90 days in jail max or $1,000 fine max. Gross misdemeanors are $5,000 in a year. But there is some discretion that the officer has about, hey, you took too long to pull over. I'm just going to give you a piece of my mind. Or maybe, hey, you took so long to pull over, I'm going to cite you with a crime. So that's one thing that we have to worry about. And I'm going to put the description to that statute if you want to look at it yourself in the description to this video. It's a very short statute, so it won't take you long to look at. Another thing that applies is, hey, what are our duties once we pull over? If an officer pulls us over, what do we have to do? Do we have to tell them our name? Do we have to give them our identification? Are they allowed to direct what we do? Well, in this state, there's another statute that basically gives the police officer authority to demand your driver's license, to request your name, to request your insurance and registration. They can run your name for warrants. They're instructed to in a statute. They can also check to see if the car is stolen. They've given actually authority to do that in statutory law. So they can even order you out of the vehicle. Now, they can control passengers as well, but passengers have typically a little more right to walk away, but the driver can be detained if the officer has reasonable grounds to believe that an infraction even was committed. It doesn't even have to be a crime. So if you fail to give your name, or you fail and you refuse to give information to the officer, well, then you can also get cited with the crime. And I'm going to put a link to that statute in the description as well. A third type of bigger problem you could run into is felony eluding. Okay, in this video, we're not going to get into the felony part of things. That's going to be a separate video I cover. But think about it as, hey, a police vehicle is pursuing you, and you're not normally stopping. It's not like you didn't notice it. You're taking off and you're endangering other people. And if that's what the officer thinks happened, then they can cite you with felony elude. Very serious. And I'm again going to cover that in another video and what that's all about. So what do we do in this situation? How do we handle this type of situation if you're charged with some type of failure to obey crime? Well, that's a good question. One of the main ways we can defend this type of charge is to point out that maybe you didn't notice the officer. Maybe you didn't notice that the officer was actually signaling you to pull over. I've seen that type of case before where, there's no reason you think that they might be pulling you over, and you keep driving and the officer's getting more and more mad and you just don't know it. And so that might be one way to defend, because, you have to have knowledge. Like, how is the officer going to prove that you knew and you were paying attention to that, police vehicle behind you? So that's one way we could try to defend these type of charges. A second way that these charges could be defendable is you didn't know it was a police officer, right? Maybe it's an unmarked car. And, let's face it, these are dangerous times. If there's an unmarked car that has, some police lights somewhere in it, is that really a police officer's vehicle or not? Especially a female driver may be particularly hesitant to pull over in an unpopulated area to a car that is not clearly marked as a police vehicle. And so that's a pretty strong defense that we can make to a prosecutor, and if we have to a jury, that it wasn't safe to pull over on the side of the road at midnight or 1 a.m. to a vehicle that doesn't have police decals on it. It could be anybody out there preying on people, and especially women. So that is another defense that we may be able to assert. Inexperienced driver. Maybe you did realize that the police car was in back of you, but maybe you weren't sure what to do, right? There needs to be, for criminal law, for the most part, mens rea, which means evil intent. And so it's maybe not specifically written into the statute, but it's a pretty good argument that we can make to a prosecutor, to a judge, to a jury, if it's a new driver out there and there's really no harm meant. So what are some possible resolutions of this type of case if you're interested in this area of the law, or if you're dealing with it? Well, what we want to try to do is avoid a conviction. It's not going to suspend your driver's license, but a criminal conviction on your record is a pretty big deal. This is criminal traffic, so it's less serious than normal criminal, at least in my opinion. But we'd like to either get the case dismissed or get it changed to some type of traffic infraction, something more akin to, what was going on here. If it's you didn't give the officer your name properly, that type of thing, or you gave a false name, well, then it gets a little more complicated. We need to come up with, why you were scared. Why did you give a false name? You were afraid your parents were going to find out that you were, in trouble, and you didn't want them to know, or if you have no experience with the police and you just sort of panicked. So in those cases, it's a little bit harder. We might need you to do a little bit more to try to get a result, but there is hope. Typically speaking, unless it's the most egregious case like a felony, prosecutors typically aren't the most upset with this type of case because usually there's no harm done. Usually it did inconvenience an officer, and it's not great, but it's not the most morally reprehensible type crime that can be charged like other type of things that prosecutors see. Because let's face it, there's only so much time in the day that a prosecutor has, and so much energy, mental and emotional, to put towards cases. So what we want to try to do is get anyone charged with this doing the right thing. Maybe we have you do a defensive driving class, an aggressive driving class, maybe have you do some community service, but we just need to get across to the prosecutor that you're not a bad person, that this wasn't super intentional, or if it was just a moment of panic, and we need to make sure you don't get convicted of a crime. So I hope you found this video helpful. If so, please like and please subscribe. And more importantly, if you're in this situation and you have this type of charge or anything akin to this, feel free to give my office a call. Again, my name's Lance Fryrear. I have a 5-attorney firm that's been defending people charged with crimes for more than 20 years. We'll listen to what happened. We'll identify a way forward, and we're going to try to get this behind you as soon as possible. We'll be there for you. Thank you.